Welcome everyone. Thank you so much for being here. I'm really glad to see so many people here tonight. We have about 175 registrants for this webinar, and I'm so excited that Kimberly Glassman and Brian Gruber are here to speak with us tonight. I know them personally. I think they're great people and certainly great attorneys. So we're very fortunate to have them here tonight. I'm Stephanie Frumkin. I'm the MCCPTA Special Education Chair. So we have a committee and I am the chair, and my co-chair, Rachel Tate. She's unfortunately not able to be here tonight. But we advocate for students with special education needs in our committee. And I am a special education parent. And by profession, I am a former teacher, and currently I'm an educational consultant. And Rachel, she is a teacher. We both have masters in education, so we're very passionate about education and passionate about making things right for special education students, especially in MCPS. I know there's a big, with so many registrants, we know there's a lot of interest, obviously, and it's something that I can tell from, I follow parent groups. I talk to a lot of parents, both in my role as a special ed chair and also just in my professional life, and just talking to a lot of parents. I know parents of students with disabilities are struggling to get their needs met. So we have a focus this year on know your rights. And that's why especially we thought it was great to have Kim and Brian talk tonight, because we know that you want to know what your rights are. And so this presentation is called Solving IEP Meeting Disagreements, Legal Paths for Resolving Special Education Issues. And they're going to go through different legal paths for, solving. They'll go into the topic a little bit. Let me introduce them. So Brian Gruber. Brian has been representing children with special needs and their parents since 1997. Mr. Gruber is well known in his special education circles as a collaborative advocate who is often able to obtain the desired outcome for his clients without having to resort to adversarial and costly litigation. He has participated in over 1,200 IEP meetings spanning several states and more than 24 different school systems. As a special education trial lawyer, Brian has been lead counsel in more than 300 special education mediations and due process hearings, and has appeared in federal district courts as well as the DC Circuit Court and Fourth Circuit Court of Appeals. In 2003, Brian was admitted to the bar of the United States Supreme Court. And I will attest that he does have a reputation of being a very collaborative advocate and attorney. So, and about Kim Glassman. Kim Glassman has represented parents, legal guardians, appointed education decision makers, and adult students in all phases of special education matters since 2005, including at IEP meetings, student discipline, and special education mediations, due process hearings, and appeals. She's a member of the special education attorney, guardian ad litem, and counsel for child abuse and neglect panels for the District of Columbia Superior Court. Kim has participated in hundreds of IEP meetings, special education mediations, due process hearings, and has appeared in federal district court in the District of Columbia. Kim serves as a local PTA president, delegate, and Magruder cluster coordinator. And I've enjoyed working with Kim on different special education initiatives this year. It's been great getting to know her. So with no further ado, Brian and Kim, please.
So Brian and I think we'll bounce off each other, and I will control the slides and take it from there. We wanted to start off with talking about the role of an attorney in the IEP process. And Brian, if you want to get started, I can click through some of the bullet points while you're going.
Sure. So I think the first thing I want to do is perhaps make a correction. When I saw the description in the bio mentioning 1,200 IEP meetings, I think I would flip those numbers around. It's probably about 2,100 IEP meetings. This is my 27th school year representing parents, and I spend probably 50% to maybe as much as 75–80% of my work week in IEP meetings. I think just today alone I did 3. So it's pretty significant part of my practice, and I know that to be true for Kim as well. And I share that because the topic of our slide and the question coming in is the concept of bringing an attorney to the IEP process. And oftentimes there is a perception amongst parents and potentially educators as well, that bringing an attorney into the IEP meeting somehow makes the process adversarial. And I think that is a misconception that I know I, for one, work very hard to overcome. The role of an attorney at an IEP meeting should be a few different pieces. One is that the attorney should be there to represent the rights of the parent and the child, and to know their rights, and to keep the process as a train moving on the right tracks, to making sure that the focus remains on the child and on what is valuable and important information about the child. The second is to almost be a translator for the parents in terms of the jargon of special education and the way that it impacts their child's rights and their right to a free, appropriate public education. And the third is to be hopefully an effective collaborator with the school-based IEP team to help make decisions that are going to be appropriate for the child. And not every meeting has a happy ending. Not every meeting resolves in agreement. But attorneys who practice in the field of special education, who speak the language of special education, who are fluid about the rights and responsibilities, who are knowledgeable about the guidance that school systems receive, both from the school system themselves, as well as from the Maryland State Department of Education, as well as the U.S. Department of Education, enables school teams to make better decisions for children. So Kim, I don't know if you want to add to that. And let me just add as a technical, I'm getting bombarded with chat messages, so I'm going to try to figure out a way to shut that off so that I don't lose focus, but I do encourage everyone to keep bombarding the chat because most of the comments have been enjoyable.
Yes, and I can monitor the chat as well. I would say, to add on to that, I think for me, the most important part of this job is the relationship piece. I've been a PTA president. This is year 4. This is year 2. I've been a cluster coordinator. I've been a PTA special education chair. So the most important thing to me as a parent is the relationship I have with my kids' schools. And I know that's the same for everybody else as well. I had a parent ask me a few months ago, like, my last lawyer was friends with all those people and they acted like they liked each other. And I don't want that in my lawyer. And I said, well, like, you probably don't want to hire me then. Because for me, if I walk in there and we don't have a positive relationship, we're not going to solve any problems. It's just going to create a situation that doesn't need to be there. So I think that relationship piece is really critically important, and knowing that even if you don't end up on the same page, you're there for the same purpose and you're trying to resolve problems together, even if it's ultimately a little challenging along the way. So I thought that was an important point to bring out. And I think someone also asked about an advocate versus an attorney. For me, the primary difference is who can litigate and who can't. And I don't know if, Brian, you want to add on to that at all. But for me, I think there's a different role for a different professional depending on the circumstance.
Sure. So non-attorney advocates come in sort of different shapes and sizes, if you will, from a professional standpoint. And there are some that are really extraordinarily effective and do a lot of the same things that a good or experienced attorney can do, and others who who perhaps are well-intentioned but not as skilled within the advocacy portion. So I think we need to make a distinction between somebody who is an advocate as opposed to somebody who is an expert or a consultant. And this is, to me, this is the big difference. And then I'll dovetail back into the difference in terms of roles, because to me, it's a little bit more broad than just who can litigate. There are professionals who sometimes call themselves advocates, but are really serving the role as a consultant, somebody who does perhaps their own assessment or does an observation and brings with them a background in special education or in one of the subdomains that impact kids with disabilities, sometimes behavior, sometimes language, academic learning, whatever it may be, and shares their expert opinion with the parent, who then forms and based upon that opinion, the parent formulates what it is that they are looking to have happen. Okay. And that's an expert opinion, and that is something that can be very important to share with an IEP team. Now, sometimes the consultants or experts take on an advocacy role and will come to an IEP meeting and represent to the school-based members of the IEP team their opinion about what they would like to see happen and the justification for that. And that's one column of advocate. There's a second column of advocate with folks who are oftentimes well-trained, who are knowledgeable about special education law, special education procedure, some aspects of the substance of special education, and they are functioning in the true role of an advocate, which is that their client has formulated a decision or a position or an outcome, and it becomes the advocate's role to try to get that outcome. So attorneys by nature are advocates. Our ethical responsibility is to be zealous advocates for our clients. Good attorneys, and hopefully Kim and I fall well into this category, use our experience to formulate opinions and share and guide our clients, but ultimately the client determines, and the client being the parent, determines what it is that they are looking to try to make happen. And it becomes our job to essentially sell that version to the IEP team, and hopefully with the credibility that we bring to back it up, particularly if that decision was made in conjunction with consultation with the parent. But an advocate is somebody who, by definition, is trying to obtain the result for the family. And so to me, those are important distinctions. Now, where it comes back to the conversation about the roles that they play and what Kim said regarding about who can litigate, in the state of Maryland, only an attorney or the parent can represent the child at a due process hearing. So you need to be a licensed attorney in order to conduct a due process hearing. And we'll talk much more about that a little bit later on. But if you are in a dispute that results in a due process hearing, you may as a parent, you may very much want your consultant or expert style advocate to be testifying and to be telling the judge why their position or their view is more correct than what the school has proposed. And if you are serving the role as an advocate, it is wearing both hats can be challenging. So when we talk about an advocate, I think it's important to draw that distinction between what type of advocate you are looking to or considering utilizing, and whether that person can wear one hat or both hats effectively. But there are many advocates who really do a very nice job in terms of working with school-based teams, and I appreciate the work that they do.
So the next few slides will, there goes my share, we'll just talk about, what happens if I disagree with the outcome, and we'll go into detail about each of the dispute resolution outcome or options. But this is more of just an overview. And when I was showing the slideshow to Stephanie, and I was like, okay, so everything goes in the prior written notice. She said, can you please explain that more? I don't know if you want me to field this, Brian, or you want to jump in, but the prior written notice is a very brief summary that you get after the meeting that's supposed to do a lot of things. It's supposed to document things that were proposed or refused, why that was proposed or refused, anything else that was considered, assessments that were considered and relied upon. But oftentimes what we get back is something a lot shorter than this very meaty description. But I think the important part is that if you disagree with something, this is where you should say, okay, I disagree with you on this, and you need to document it in this very specific way and place.
So let me tack on that I didn't write the Individuals with Disabilities Education Act, and I had no role in writing it. But I am very happy to point out that there are some word choices in the law that drive me crazy. One of them is the disability classification of other health impaired, which makes it seem as if it's an other category, as in we don't know what the disability is, so we'll stick it here. This is the one, though, that I think I wind up spending more time explaining to families than any other poor word choice, because it's a prior written notice, which leads parents and some school teams to believe that it is written notice prior to the meeting. But it's prior to implementing the decisions that were made at the meeting. So the prior written notice actually is generated after, not prior, but after the meeting, but prior to implementation.
And at every one of these IEP meetings, and usually at the beginning, you are handed your parental rights, and you're told that if you disagree, here's your book that tells you what you can do, including requesting mediation, a state complaint, or a due process complaint. And we will talk about each of those. One thing we really wanted to highlight is that a due process complaint initiates a process that is very similar to a trial. So something that always bothers me as both an attorney and a parent is when at an IEP meeting, you're reaching a point where things are going a little bit south and someone chimes in, well, if you don't agree with us, you can just file due process. Your attorney can tell you what that is. And it is not something that should be taken lightly or treated as if it's something that's simple. That is really not only a monumental decision, but it's setting up a really significant process. And we will talk about that more in more detail. And just two other points that we wanted to point out here, is that if you disagree with something, definitely ask that it be documented. And if you're at a meeting where you're going round and round and round in circles, and you're making a point, and then they're making a point, and you're making a point again, that's when it's okay to say, this isn't really productive anymore. So before there's some harm to our relationship, let's end this conversation, agree to disagree, and move on to whatever the next step might be. I think sometimes parents are, one, you're advocating, you want to be zealous about your child and what you want, and then it's hard to let go of that point. So I find it important to just recognize when we've reached the wall and it's time to get out.
So those are great points. So let's talk about the unfortunate. So I think the first thing I want to say before we do that is I don't want anybody who is part of this program to have the impression that IEP meetings regularly result in disagreements. I don't have the data point readily available, but I would venture to say that the vast majority of IEP meetings end in agreement. It is not, it is not the norm for families and school teams to be at a point of disagreement. With that said, disagreements do happen. So it's important to understand that there are different options available when you do reach a disagreement, and what the substance of that disagreement really determines which path you may want to take if you are looking to exercise one of the formal dispute resolution paths that are available under the IDEA, under our nation's special education law. So the first that I think we should talk about in terms of formal dispute resolution options, or we'll follow the slide and we'll talk about informal first, then we'll come back to the formal. So within Montgomery County Public Schools, there is an office known as the Resolution and Compliance Office, or sometimes the acronym RACU, R-A-C-U. And it is it's run at the moment by an attorney named Diana Wiles, who is very child focused and functions to some degree sort of as an ombudsman's type office, but they are but her office is set up to receive concerns from parents and to attempt to find some resolution. Within the framework of special education within Montgomery County, there are special education supervisors, who support and service particular cluster areas, and there's also leadership within your individual school. It's always a good idea to try to resolve disputes informally whenever reasonable and whenever possible. And I'm a big proponent of trying to network with the various people who could potentially be involved with your child's education to see if you can have a conversation between parent and educator to see if there is a reasonable way of resolving things. The Resolution and Compliance Office, the RACU, does offer something known as administrative review. It is somewhat unique to Montgomery County. It's not part of IDEA, but it is something that Montgomery County Public Schools has been using during the 27 school years that I've been involved in these cases. And it's not a process that I regularly use. But I do know families do use it, where you are asking the director of that office, in this case, Diana Wiles, to review the file, to review the case, and to see if there is, if errors were made. Now, the types of errors that we typically talk about in an administrative review are going to be things related to process and related to compliance. You are unlikely to be successful if your complaint involves wanting a change of placement, the appropriateness of the IEP, or things of that nature. But if you are concerned with the amount of time it is taking to get a speech and language evaluation completed, or thinking that you need to have somebody from the autism unit do an observation and a consultation on your child, or something, something along the lines of compliance and process, that's an informal way to resolve things. Now, shifting over to the formal, and I'll kick it off, and then Kim can will tag on. Of the formal dispute resolution avenues, a complaint to the Maryland State Department of Education is something that is mandated by IDEA. And when I talk about this with families, many times you feel like you are, when I talk about a complaint, parents feel like it's comparable to sending an email to the manager of a restaurant where you had an unpleasant meal, and that's not at all what a formal MSDE complaint is. This is a mandated function of the dispute resolution features of IDEA. Complaints to the state of Maryland are wonderful for a few reasons. One is that they are at no cost to parents. They are not complicated. Second reason is that they're not complicated to file. You can simply use the form that's available online, or you can write your own letter and you just write out in layman's terms what it is that you are complaining about. You file it with the state office with a copy to the Resolution and Compliance Office at Montgomery County Schools. As soon as it is received from the state, an investigator from the Maryland State Department of Education will contact you as the parent to discuss your letter of complaint. And they will narrow down the legal issues that are involved in the complaint. And then they will contact MCPS to ask what the school system's position is on the complaint. And if the school system believes that they're in the right, and then MSDE will investigate. MSDE is obligated by law to complete their investigation and issue what's called a letter of finding within 60 calendar days. So I'm a big proponent of using state complaints where they are appropriate.
You covered like 3 of my slides, Brian.
Well, then why don't you pick up on anything I left off?
Sure. I feel like you covered all of it. I think for me, with a state complaint, I like state complaints when it's something that is a clear violation that is seen, that is evident in documents, in emails, etc., and is not, I think a placement dispute is not the best place for a state complaint. I can give an example of one that I filed for my own child a few years ago because I was irritated. He didn't have a piece of computer equipment and software that he was required to have by his IEP, and it was taking months and months and months and months to get Google Read and Write enabled for a particular student who had dyslexia and dysgraphia. And a state complaint solved that problem really quickly. So those are some opportunities, I think, for state complaints. I didn't mean to cut you off. I just was trying to catch up my slides to your talking.
That's great. For those of you who have heard me speak before, I'm not a PowerPoint or slides guy. Even sitting in my seat is challenging for me when I know that there's an audience. And I should have said this earlier. I think this is a repeat performance for me. I spoke to this group probably less than 10 years ago or so in an auditorium at MCPS. So maybe 2 or 3 times. So it's nice to be back on that. But in any case, let me stay focused on you and not me. The only caveats that I have with state complaints are that MSDE will typically restrict its investigation to issues of compliance and process, similar to the administrative review that I spoke about before. And the second is that they will only go back 1 calendar year. So if you have been allowing a disappointment to fester for some time, and it has been more than 1 calendar year, and now you filed the state complaint, MSD is not going to investigate. They really are pretty strict about that 12-month statute of limitations on what they will go back and investigate. But again, questions of process and compliance are wonderful for the state. If you think that your child's IEP is not being implemented with fidelity, if it is taking too long to get evaluations, if you are struggling to get IEP meetings scheduled, then absolutely a Maryland State MSDE complaint is a good way to proceed. Somebody put in the chat a question about whether COVID impacted the 12-month statute of limitations for state complaint. No. So you really only have that 1-year period in which the state will investigate issues of process and compliance. Again, this is not traditionally it has not been an effective tool to use if you have substantive complaints, such as the MCPS has proposed that my child go to the Learning Center at Burning Tree, and I want my child in a non-public program. That's not going to be an effective use of a state complaint. But if you are saying that your child has an IEP that clearly says that they will be receiving an evidence-based multisensory reading intervention to focus on phonemic awareness and decoding 5 times a week for 45 minutes per session in order to be able to deliver the program with fidelity. And you sign your initials, lover of OG, and you send it off to Maryland State Department of Education, and they come back and they look at service logs, they talk to school staff and find out that your child's been receiving intervention once a month. They're going to rule in your favor. So that's the kind of complaint that is very appropriate for MSDE. Here's the last thing I want to say on it, and Kim, you can certainly tack on as you wish. There's a general rule that in that if something happens once, it's an incident. If something happens twice, it's a coincidence. If something happens 3 times or more, it's a pattern of practice. And that's a really important concept to understand, because when you file a complaint with the state, MSDE is investigating your individual complaint, but you may not be the only parent filing that same complaint. And so if they are investigating your situation and it's unique to your child, it's going to be an incident. If they investigate it and it's a couple of kids in that same class or in that same school, they may view it as a coincidence. But if they get to the point where 3 or more students are similarly situated, they're having the same issues, the parents are complaining about the same thing, now we're going to be in a situation where the state is most likely going to want the school system to take systemic corrective action. And that can be very powerful, and that can be a really effective way of creating massive change for families. So this is a good tool to use.
Yeah, I think the only other piece I would add on to that is, there have been times where I filed a state complaint on behalf of student X and all similarly situated students for that reason. And there have even been times where I filed state complaints over something I knew that was wrong, but I didn't have a plaintiff, if you will. But I had a situation that I knew was a unlawful action, and a state complaint was a way to get an investigation going of that action, and it resulted in a letter of finding and corrective action. The only other tricky piece about the state complaint is that you can't appeal an adverse decision. You are stuck then with the due process complaint to try to undo the state complaint decision. And then the state complaint decision gets attached to the due process response by the county. So that could put you at a disadvantage if you are trying to then go to a due process hearing over something you were unsuccessful in a state complaint.
Well, generally speaking, unsuccessful is not a good situation to be in.
Yes. So if your state complaint is unsuccessful, that might practically be the end of the road, even if there is another alternative from there. Next up, we wanted to go through mediation. And a parent or the school system may request mediation for anything related to identification, evaluation, or educational placement, or other provision of FAPE to the student. A mediation request can be something you file on its own, or it can be part of something you do with a request for due process. Both parties have to agree to mediate. So if you want to mediate and MCPS does not, that ends your mediation conversation. Same thing with the other way around, though I can't think of a time I've had MCPS request to mediate, but I have had that come up with other school systems. And mediation is an opportunity to resolve your dispute without going through litigation. An administrative law judge presides over it. Back in the day when Carver was a place where we went, it was physically at central office. Now everything is being done electronically. And a lot of times a mediation without having to have a due process complaint attached to it is a really effective tool to get everyone kind of in the same room, talking about the child, having a very child-focused conversation, but having an administrative law judge who's knowledgeable in the IDEA to recognize weaknesses on both sides and help reach a compromise, which can be really helpful for both parents and school systems to get to a middle ground that makes sense or a resolution that makes sense. I know, Brian, you're the mediation guy, so I went through that probably faster than I should have, but process-wise, requesting mediation is something that can really get a stalemate to a different set of people to have a more thorough conversation and help get to a point where you can stop the process there because you can reach an agreement.
So I use mediation a lot within my practice when if in the circumstances where we are not able to resolve things informally. Let's talk about what mediation is and what mediation isn't. So I want to do some parallels if we can. A misperception is that mediation is something akin to another legal concept called arbitration. Arbitration is two sides come in, you argue before somebody, a neutral third party, and the neutral third party decides between the two of you. That's not mediation. Mediation is a voluntary process, and voluntary on two levels. As Kim said, you as a parent can request mediation, or the school system can request mediation. And I have had MCPS request mediation as recently as a couple of weeks ago on a case of mine. The other party, be it you or MCPS, does not have to agree to mediate. It's voluntary. Your participation in mediation is voluntary. The second part that's voluntary is that there is no obligation at mediation to reach an agreement. And that's where it's entirely different than arbitration that I referenced a moment ago. And when we talk in a few moments about due process, this is where it is entirely and completely different. Right? At mediation, there is no obligation to reach an agreement. It's a conversation, and it's a conversation facilitated by a neutral third party who happens to be a judge, knowledgeable about special education. Some judges are better at conducting mediation than others. Some, frankly, get in the way. Others are really good at assessing the facts and circumstances and sort of helping either side to understand what the strength and weakness of their case may be. What I often say about mediation is that for parents, it's all upside and really no downside. And the reason that I say that is because you are not under any obligation to reach an agreement. And so you may come into mediation and you may present your side of the case, your argument, what it is that you want, and MCPS may offer you something that is less than what you are asking for. You don't have to take it. If it's not what you want, if it's not agreeable to you, you can say that's not agreeable, and the mediation will likely come to an end. You're not obligated to accept an offer that that's made. And so you can't come out of mediation worse than you went in. It's an all upside proposition, but it's a very effective tool to use as a way to try to bring a group of people together to focus on your child, to focus on what the dispute may be, and to try to avoid escalating your dispute into something greater. I have used mediation effectively to change placement, to obtain independent evaluations at public expense, to make changes to the IEP, to talk about compensatory education, to talk about concerns with complaint or process or implementation and resolution there. It's a friendlier way of trying to resolve your case, but has the formality of being overseen by an administrative law judge and having their cooperation and sometimes their assistance in getting the school system to see your point of view and get to a resolution. The last part I want to say about mediation, and one of the reasons I like it very much, is that any agreement that's reached at mediation is binding. Kim, you read my mind in putting on that last part of the slide.
I knew it. I sensed that was coming next.
Agreements reached at mediation are binding, and they can be enforced in state court or federal court. I cannot think of a situation where we've reached an agreement at mediation and have had to enforce that agreement in court. Sometimes we have to push a little bit to make sure that things get done within the time frame that we agreed upon, but that's life. Agreements reached at mediation are binding. And so if you do reach an agreement, you have the comfort and security of knowing that it's going to be carried out. It's actually going to happen. And then I guess the last part, I correct myself when I said that was the last. The other piece about mediation that, again, I think is important to keep in mind is that when you sit down to do the mediation, you will be asked to sign a confidentiality agreement. This is part of federal law. This is not specific to MCPS or to the state of Maryland. This is part of IDEA. Conversations at mediation are confidential. And so because they are confidential, they're oftentimes a good way of getting folks to be a little bit more relaxed, to have more, and to have more open dialogue in terms of trying to reach the resolution.
And I know I've had a lot of really difficult situations go through mediation, and having that neutral third party really there to pull aside either party to say, you might want to let go of that point, or, oh, I see your point, let me go talk to the other side, I think really does go a long way in getting problems solved and getting people to a place of comfort and knowing that they've reached the right outcome for their child, even if that is a compromised position. So I think we probably both use mediation quite a bit for those reasons. So the next process is a due process complaint. And I think, again, I will go through the procedures and then kick it to you, Brian, for some of the substance. But just like mediation, it can be filed by a parent or the school system of any allegation on the same things related to identification, evaluation, educational placement, or the provision of FAPE. A due process complaint has to be filed within 2 years of the alleged violation of when you knew or should have known, which is a complicated legal concept that I am not going to try to go into in this forum, but it is generally a 2-year statute of limitations. It is an administrative lawsuit filed against the school system. It's assigned to an ALJ, and it's a legal proceeding that is similar to a bench trial. So before a due process hearing, parties have to engage in either a resolution session or a mediation in an effort to resolve the complaint. I feel like in MCPS, it's almost always a mediation that I'm asking for rather than a resolution session. I don't know if, Brian, your experience is different. A resolution session is what it sounds like. It's an opportunity for the parties to come together to try to resolve the complaint. It's required by the IDEA if there's not a mediation. But there's no neutral third party. That is just purely a conversation between the parties. And think I covered some of this already. Someone had asked earlier, how long is a due process hearing? I've had due process hearings that are 5 to 7 days of rather intensive litigation. So the parents in the school district are each presenting their case, their witnesses, their evidence. So the process itself really depends on how many witnesses each side is calling, but they can be rather lengthy procedures. And I would say, I don't remember the last time I had a due process hearing less than 2 full days. So 2 days would be a speedy one nowadays. You have to follow rules of procedure to enter evidence into the record. You can subpoena witnesses and cross-examine witnesses from the other party. Decision of the due process hearing can be appealed to federal court. And I think I forgot to add in here, the timeline is supposed to be 75 days from when you file to when you get a decision. But in real life, it tends to be much longer than that because you have to worry about scheduling this multi-day procedure where your attorney, the school district, their attorney, and the judge are all available. So oftentimes it can be a much longer timeline to actually finish the process. So those are kind of the big picture processes of a due process complaint and hearing. I think what I really want to emphasize is that it is a trial in miniature. So it is something that has a lot of legal rules that there's a reason that I would say Maryland says it's either an attorney or the parent is doing it on their own. It's not something that a non-attorney should be litigating themselves.
So let me overcomplicate things within this conversation. First of all, a due process hearing, the perception that a due process hearing is something that will happen within a fairly quick period of time is, as Kim said, is not really accurate. The federal regulations anticipate a 75-day window, but in reality, I cannot think of the last time that we've had a due process hearing that came even remotely close to 75 days. More realistically, you are somewhere in the neighborhood of 4 to 6 months from the time that you file until perhaps you have a decision. The decision from the judge in a due process hearing is a written decision, and it is appealable to United States District Court, to federal court. Now, when you file an appeal to federal court, the court is not starting the case over again. It's what's called a paper appeal. The court is going to review the transcript from the due process hearing and the judge's decision and give an independent determination about whether the judge applied the law and the evidence correctly and consistently. And so what's involved in that are dueling briefs from the attorneys. There's no timeline on the appeal process. You do have 90 days from the date that you receive the adverse decision to file the appeal. But beyond the limitation in terms of when you have to file the appeal, the federal court can take as long as or as short as they want. I've received decisions from federal court in as little as 6 months and as long as 2.5 years. If you don't like the decision from the federal court, you can file yet another appeal at the Fourth Circuit Court of Appeals. The circuit courts of appeals in the federal court system are the second highest courts in the country. And at the Fourth Circuit, that court is going to look at the decision from the U.S. District Court and look again back at the transcript from the due process hearing. And if you don't like the decision from the Fourth Circuit Court of Appeals, you have one stop left, and that's the United States Supreme Court. In some cases do ultimately reach the United States Supreme Court, but they reach the United States Supreme Court based all the way back to the decision that happened at the due process hearing. The due process hearing is your one and really only chance to put on your evidence and your case. So if you decide that after your due process hearing, I should have called, I should have asked, a psychologist to provide testimony. When you're on appeal at U.S. District Court, it's too late. You can't now ask the court to hear that information. There are some nuances in which the court will hear information or receive evidence that was not part of the due process record, the transcript and the evidence in the judge's decision. But those are very unique circumstances and very typically involve things that happened after the due process hearing or very unique circumstances. The general rule is that if that information or that witness was available to the parties at the due process hearing and they chose not to call that person, that's over. So a due process hearing really needs to be taken very seriously, only filed when you are, when all of your ducks are in a row, if you will, when you have all of the evidence to support your claim. You can't build your claim after you filed for a due process hearing. So here's what I mean. You have a dispute with the IEP team. You think your child needs to be in, in a non-public program, in a private school. I'm just going to pick one for the sake of illustration and nothing further than that. You think your child needs to at Ivy Mount. And MCPS is proposing that your child should be in the general education classroom at Lux Manor Elementary. Just picking names out of a hat. No, don't read anything more into the conversation, please. And now you decide you're going to file for a due process hearing. And then you think to yourself, who can I have as a witness to testify? I'll get Dr. So-and-so. Well, if Dr. So-and-so hasn't evaluated your child, hasn't been part of your child's life, hasn't formulated an opinion base that the IEP team would rely upon, Dr. So-and-so is not going to be a credible witness at due process. So you have to have all of your witnesses, you have to have all of your evidence essentially in hand at the time that you file for due process in order to be able to satisfy the next concept that I want to talk about, which is the burden of proof. And this is a big hot button, and I'm going to try to take it a little bit slower, not because folks need me to, but because it requires it. The burden of proof determines which side has to actually prove their point. The side that does not have the burden doesn't have to do anything. Hang on that for a moment. The side that, if you have the burden of proof, you have to prove your point. The other side doesn't have to prove anything. So here's how it plays out, and it's a very painful story that I will tell you. A number of years ago, right now, just for context, in case parents don't know, the law in Maryland, law in this country, through a Supreme Court decision called Schaefer v. Wiest that involved Montgomery County Public Schools, is that the party that is looking for change, the party that files the due process complaint, is the party that bears the burden of proof. Now, some states, the District of Columbia being one, have statutes that change that, but we don't have that in Maryland, and we don't have that in MCPS. The party that files the burden of proof, files the due process complaint, has the burden of proof. And here's where the situation is painful. And I know the judge who wrote this decision that I'm going to talk about. So so I know how much it pained him to write it, Judge Novotny. There was a case in Prince George's County shortly after this burden of proof had shifted. It was a mom and a grandma who believed that their child's IEP or grandchild's IEP was not appropriate. They wanted a different school placement. And they filed for a due process complaint. They didn't know how to conduct a due process hearing. They didn't know how to examine witnesses, to present witnesses, and to elicit their questions to ask to get their testimony. They didn't know about the rules of evidence and about how to get documents into evidence, or what we call the 5-day rule of the necessity to share and exchange your documents that you might want to enter into evidence 5 days in advance of the hearing. But they knew they were upset about their IEP, and they very well may have been right. And Judge Novotny, and so this mom and the grandma came into the due process hearing, and Judge Novotny said to them at the start of the hearing, he said, I really think you should get an attorney. I don't think you should go forward with this case. I think you should get an attorney. And the mom and the grandma believed in their heart of hearts that they were right. So Judge Novotny let them proceed. And Judge Novotny said, and he wrote this in his decision, he said, it's not my job as a judge to tell people how to conduct themselves. It's my job to decide the law and the evidence. And I strongly advised this family to get an attorney, and they refused. So I have to proceed. They didn't have any documents to enter into evidence. They didn't have any witnesses to call. I allowed them, each, the mom and the grandma, to get on the stand and tell me their story. But at the end of the day, I have to rule on the evidence. And they didn't give me any evidence, nor did they enter the disputed IEP into evidence. And the school system didn't do anything in its defense, but they didn't have to, because mom and grandma had the burden of proof. And so Judge Novotny wrote, and I had just done a case before him, so I knew him and I understood how much this pained him to write this. He said, it bothers me because I don't know anything about the kid. And I have reason to suspect that there are problems with the IEP, but I can't decide that because the IEP isn't in evidence before me. And I don't have any testimony to rely on other than mom and grandma's belief that something should be different. So I have to rule against them. And he did, and he was right. It was painful because the school system likely didn't put on any witnesses or didn't present any evidence because they knew that the IEP was probably not appropriate. But they didn't have to. They didn't have to defend their case because the burden of proof was on the parent, and the parent didn't know how to do this. Now, that's a very strong example, but it's an entirely true story. And so a due process complaint is your most powerful weapon. It is, the decisions are binding on all the parties. Like I said, it's if either side, if you win, the school system can, it can follow that same appeal path that I spoke about. It can be a very powerful, very exhilarating experience to be successful. But if you walk out of here with anything, if you walk out of anything, it's my plea to you to take it extremely seriously when you are contemplating a due process case, because you must be organized and know what you're doing, and unless you are a skilled attorney yourself, this is an area where you must have legal representation.
I think I'm going to go ahead and stop the share because the only thing left on the screen is questions. and it looks weird on my end when I'm sharing my screen. I can't see all the boxes. But there was a question in the chat that I wanted to address that was, can the child still go to school when a due process complaint is filed and pending? And the answer to that is yes. Not only can they go to school, but the stay put rights, which is something that's part of federal law, is that they must go to school and they must remain in the last agreed upon placement for the duration of litigation. And that's a really important tool, especially if the thing that is in dispute is changing the educational placement. The purpose of that is to provide stability to the child while the grownups are in some heavy litigation over what the right outcome will be.
Yeah, your child needs to be in school, and whether there's a due process hearing pending or not, children need to be in school. There are a few questions that I wanted to make sure that we addressed. One is a question earlier about attorneys participating in IEP meetings and whether it is prudent to have the attorney participate in an IEP meeting or only get involved when there's a dispute. I'll answer that, and then Kim can chime in if she has something different or more to add to it. I strongly believe that parents are well served by having the attorney involved in the IEP meeting before you reach a dispute, for the particular goal of not reaching a dispute. We do our best advocacy, and when I say we, I don't mean Kim, exclusive to Kim and myself. Those of us who practice in this area do our best advocacy when we're at the table with the IEP team and have a hand in, or hopefully a role in the decision making. It's also critical that if you do reach a disagreement, that your attorney is there to understand firsthand what it was that led to that disagreement, rather than receiving the interpretation of the disagreement from the parent, who is understandably emotional and probably not terribly objective because it's your child, as well as anybody else who you may have brought to the meeting. I like to hear it myself. Here's another, and I recognize that there are some IEP school-based IEP team members, in our session today. I see your names, and so you may appreciate what I'm about to say. In every IEP team, there are 3 players, and I'm always looking to identify who these 3 players are. And there can be multiple, but there are always at least 3 who will fit this descriptor. Within every IEP team, there is somebody that I'm going to regard as the mentor. This is somebody who brings the most knowledge to the team, who everybody from the school-based team is looking up to, and rightfully so. They are the person or persons who we are relying upon. And when I'm in an IEP meeting, I am trying to rely upon them as well, and to bring them into the conversation and to utilize them as a way to support the student, because they are truly the mentor to the team. There is a second person within every IEP team that is my ally. There is always somebody who, and I'm always looking for them, who is, who I'm on the same page with, and who is seeing the concerns or the version of the child that the family is representing, concerning about. And that's an important person to identify and to bring them into the conversation as well, because likely they are seeing what it is that the family is seeing. And then the third is what I affectionately call the idiot. And this is the person, and I don't mean that derogatorily, I mean it humorously. But there is always somebody who is a weak link, somebody who is the person that the rest of the team sort of cringes when they go to speak, that everybody knows this is not the best person on the team. And it's good to know who that person is, because oftentimes we can figure out where the disagreement is coming from. And many times it's coming from that person. And so when I use the derogatory term idiot, again, I do humorously and affectionately, because that's somebody for whom I'm going to want to be, be chatting with more perhaps than other folks might want me to be, because I want to figure out where the breakdown is, and I want to be able to use the mentor and the ally to be able to resolve the problem where the weaker person may be. And sometimes we're able to shift and move that weaker person off of the child's case, because the school-based team recognizes that this is an area that's now causing more disagreement or more consternation than we should have. Now, that only happens if the attorney is in the IEP meeting. So it's an important role that we can play in terms of figuring out and problem solving. The last part about it is, if you do wind up in a due process hearing, we don't have what are regarded in other legal channels as known as discovery, where you can identify who the expert witness is going to be, take a deposition, or get them to answer written interrogatories. We don't have that in special education law. So the opinion of the school staff, as discussed at an IEP meeting, is my only opportunity as a practitioner to know what they're thinking, what they're saying, and what role of the three that I described they play within the construct of that team. It ultimately is much more effective if things really go sideways and you need to be in a due process hearing, and I certainly hope that you won't be. But ultimately, it is much better to have the attorney involved in the process early on. The last part, Kim, I don't know that we spoke about this, but I want to today, but I want to make sure that we do, because we talked about it within the office, is something that I often call the value added bonus. And please hear me that I'm not trying to sell anybody on anything at the moment, but when a parent brings an attorney to an MCPS IEP meeting, MCPS will bring one of their attorneys. And very often MCPS will also assign a special ed supervisor or one of their assistants to the IEP team as well. It's somebody from outside the school who is there to add some additional subject matter information to the IEP team. The role that parent attorneys play is, as I talked about before, we are advocates for the client's position. The MCPS attorneys, for the most part, are there to make sure that the train stays on the tracks, that the school-based team makes good decisions based upon the information, based upon their concerns, follows the process, follows the guidelines. They are not really there for a substantive advocacy away from what the parents are looking for, but rather to make sure that the school team is doing what they are supposed to be doing. I often find that the MCPS attorneys can be wonderful advocates for my clients when they realize and hear the same information that we are hearing. And Kim, I don't know if you want to add to that.
Yeah, I mean, I think the few pieces I would add to that is I don't want anyone to walk away thinking you have to bring an attorney to every IEP meeting from kindergarten through 12th grade, or like it's doom and gloom. Because I don't think that's the case, but I think that if you're in a place where it's not that there's a dispute, but your comfort level is impacted, that you feel like something's not quite right, and you don't know what that not quite right is, don't wait for it to get worse. Because it's bringing someone in early enough to right the ship. And that is really something that can get things moving in a positive direction a lot faster, rather than waiting for things to really derail. I have clients, I have twins that are seniors in high school in DC that I have gone to every IEP and 504 meeting since they were in pre-K 4. And I think there are some families who just like the comfort level of having that. And it's been wonderful to see these boys grow up, and I can't wait to see their graduation pictures. And then I have people who come and go, where I might see them once, and then 3 years later, they'll come back in again because something's come up, and it's that point where they don't feel quite right, that they want to get support again. There were a few questions in the chat, Brian, I wanted to make sure that we talked about. One of them was, can you homeschool while a due process complaint is pending? And I would say the very short answer to that is no, because if you are homeschooling, you are disenrolling your child from MCPS, which means that MCPS is not responsible for the provision of a free, appropriate public education. So that kind of derails our ability as lawyers to move the case forward in the IDEA due process arena. And then Laura, I saw you had just put a question in about financial responsibility. And to answer that question, MCPS is only responsible for attorney's fees if the parent is the prevailing party in a due process complaint, which means that you have gone all the way through hearing and you have won. So the financial responsibility is not often on the school system, in realistically. And then, can you request IIS in the interim? Yes, absolutely. I think that probably happens. I don't want to say regularly, but I think that does happen.
Yeah,
and for anyone who doesn't know,
Kim, I'm going to disagree with you a little bit on that one. It does happen with some regularity, but IIS or interim instructional services, the rest of the world calls home and hospital teaching. IIS is a very specific entity that is to provide home-based instruction to students who are in a physical or emotional crisis that renders them incapable of attending any school. It is not designed to be used as a temporary placement or as a sort of a placeholder during a placement dispute. Now, there are circumstances, and particularly we're seeing a lot of this with the current mental health crisis that exists right now, where kids are in are not capable of attending school, and we are still trying to resolve where it is that they would go to school once they are healthy enough to emerge from school. And so those students would certainly be appropriate for IIS, but to file a due process complaint because you don't agree with the appropriateness of your child's placement and you're trying to obtain a different placement and you are just wanting to remove your child from what you think is not appropriate, it is really not the way that IIS is supposed to work. I agree with you, it happens. And you could, it certainly could have, there are circumstances where it might be appropriate, but I'm not comfortable. I would say that
I've seen IIS exactly in the circumstance you just provided, when it was a mental health crisis or a physical health crisis that prevented the child from being in their current school. And the IEP team is going through the process of determining where would be appropriate. So it's not as easy as it's an alternative to homeschooling, but it is something that can fit some unique circumstances that works for some kids in some situations, I think is probably a better explanation.
I agree, and I don't want to get too into the weeds on it, but I do think this is a gray area. Let me give you and everybody, an example of where I would have a concern, and I'm just going to make this up hypothetically. Is a parent has a disagreement with about the school program. They want a different school program. They file for a due process hearing, and the parent files for IIS while the hearing process is going on. It's entirely possible that the MCPS attorney would file a motion to dismiss the due process complaint, because if you are saying that your child needs IIS, you are saying that your child is not capable of attending any school, that your child is in either physical or a mental health crisis that would prevent them from attending any school. And so therefore, there really should not be any dispute at the moment. The dispute should be dismissed until such time as the child is available to go to school. And then an IEP team would take a look at how the child is doing. So that's an area of concern. I do see in the chat that someone is putting a lot of personal information about their particular child and circumstance, and I don't want to address that, not because I don't want to address you, but because addressing your specific questions is the same thing as giving you legal advice, and I can't give you legal advice in a public forum. So that's the reason I'm ignoring those specific questions that are very narrowly specific to the particular child here, and I hope you'll understand that.
I think I'm just trying to scroll through the chat to see if I missed anything. I did see that someone asked a question. If your child has a 504, but you want an IEP, would the 504 stay in place while you're disputing the IEP decision? And I think that is a yes. A 504 was agreed upon. Whether or not you want an IEP instead of a 504 is the area of dispute. So you don't lose what you agreed upon when you're going through a dispute. And I don't know if there's other questions that we missed, or if we wanted to if anyone had any other questions that they wanted to ask. I was trying to follow the chat, but I think I lost some in the middle there when there were a few questions and I was talking at the same time.
So there was one question about, and it was a little bit off topic for what we're talking about today, about circumstances in which MCPS is responsible for paying for private placement. And it's a much longer conversation, but I will sort of net it out for you. There are two scenarios. One is if the nature and severity of your child's disability is so significant that there is no MCPS program appropriate. There is a pathway through what's called the central IEP team for MCPS to assign your child to an appropriate private school at MCPS expense. The reason it's at MCPS expense is because your right is to a free appropriate public education. And so if there is nothing available within the public school system, they need to reach out to the non-public community to facilitate the placement. The second path is that if you reach a disagreement about any aspect of your child's IEP and placement, the provision of what we call FAPE, a free appropriate public education, you have the right as a parent to withdraw your child from public school, place them in an appropriate private school, and go through a due process hearing to seek tuition reimbursement and continued placement. And again, all the caveats that we gave you about a due process complaint carry over there, but that is that is absolutely your right. It does come with your risk in that if you win, it's great, and you'll get your reimbursement, and you may qualify for attorney's fees. If you lose, you're paying the tuition, you're paying your litigation costs, and you have an adverse decision against you that MCPS can rely upon for more immediate and further IEP development. But there is a path there. Again, a bunch of nice questions in the chat, some about specific students, and it's not something that Kim and I can really address specifically, but in this forum. But we're certainly happy to chat with you, through our office or online at another point where it can be more confidential and we can have more information specific to your child. For those who I see on a professional level, although your screens are off, I know what you look like, and I'm envisioning and happy to at least be perceiving that that you're here. It's always great to see folks.
Great. Well, thank you both so much. It was really a wonderful presentation. I was taking some notes. Definitely learned a number of things here. I'm sure everyone else feels the same way. It was very enlightening. So thank you both so much for a great presentation.